Welcome to today's Tech Contracts Academy LinkedIn Live conversation. I'm Kathy O'Sullivan. I'm here with David Tollen. Good morning, David.
Good morning, Kathy.
So our topic today is top mistakes in SaaS contracts. We expect to go about 20 minutes, but before we launch into the substance, we have a few housekeeping items. While we're both attorneys, this is not legal advice. It's general information for your education. This conversation isn't creating an attorney-client relationship. And if you, nor is it intended as attorney advertising. So if you have a legal issue, obviously the facts and law depend on that situation. Time permitting, Dave may address your questions at the end, so please put them in the comments. And also know that this conversation is being recorded and will be available immediately afterwards on LinkedIn. So with that, we're ready to dive into today's topic, which again is top mistakes in SaaS contracts. David, the introduction for this talk says software as a service resembles both on-premise and services. Resembles both on-premise software and services. Can you explain what that means and why is that a problem?
Yes, thank you. So the key source of mistakes related to software as a service and other cloud services is this confusion between on-premise software on the one hand and technology professional services on the other. And the way to look at it is this. In the olden days, until very late in the 20th century, the IT industry really had two offerings. On-premise software, you could look at that as a product. That was their product, software that the customer got a copy of and ran on its own computers. And then IT professional services, which is not very complicated. It's a human being providing assistance like programming or tech support or implementation assistance or whatever it might be. Until then, late 1990s, that it wasn't so hard to understand what the industry was offering. But then this new thing came along, which I often call cloud services, and software as a service is the best known example of it. And that muddied the water. The new thing is it's like a product. It's software, basically. Software as a service means you're offering software. But unlike on-premise software, the customer doesn't get a copy. The customer doesn't get its hands on it. In fact, it's called software as a service because the vendor provides the software remotely. The vendor sets up computers connected to some system, almost always the internet, to give the customer access, and the customer gets remote access. So the problem is that software as a service has features of both products and services. And so if you're doing a SaaS deal, you might think of what's being offered as like on-premise software, in which case you draft a contract that looks a lot like an on-premise software license agreement. And that's fine, except when you get to the point where software as a service and on-premise software diverge, like the fact that the customer doesn't get a copy, like the fact that the customer doesn't get or need any meaningful intellectual property rights, a license to reproduce, for instance. So yes, it's a product and it looks like on-premise software in a way, but there are real differences. You might also confuse software as a service, particularly given the use of that word service, with professional services, with a service provided by the vendor. And again, okay, that will work to some extent. There are some terms in a software as a service or another cloud services deal that do look a lot like those of professional services contracts. But at a fundamental level, we're talking about something very different. The customer isn't buying a service. The customer is really buying access to technology. And so once again, you have some similarities and some differences. If you go about drafting your contract with a model based on on-premise software, you're going to be partly right and partly wrong, and you have problems. And if you go about drafting with a model based on professional services, you're again going to be partly right and I'd say largely wrong. And so this is really the source of communication. This is the source of the errors that I see in contracts about software as a service and other cloud services. It's also the source of, I do expert witness work. That you see a lot of cases where there's a misunderstanding of the role of on-premise software because one party or the other, of software as a service, one party or the other is treating it like either on-premise software or professional services, and that creates a mess. That is why we have this problem.
So before we get to some of the specific contract terms that you see that are problematic, is there a better term? Is there a term you'd suggest instead of software as a service?
I wish we could switch terms. The better term for software as a service would be hosted software. And there are certainly people who are using hosted software for software as a service. And by the way, this would also apply to platform as a service, which is hosted software. It's just a different version of cloud services, and even infrastructure as a service, which is also cloud services. You could just call hosted hardware. So it would be better if the industry had not settled on terms like software as a service, because it just generates so much confusion. It pushes a lot of people's thinking towards the professional services side of the equation, leading them really to make very serious mistakes. If you're gonna get it wrong, I'd sort of rather you mistake software as a service for on-premise software, because I think there's more connection. But better not to get it wrong at all, and to recognize that we've created a middle category, that the two are entirely separate. That on the one side you've got software, software as a service. In the middle you've got software as a service. On the one side you've got on-premise software. And on the other side, you have professional services.
So why don't we get into some of the specific types of contract clauses you see that are incorrect with respect to professional services? And by the way, I think you've frozen, but we can still hear you.
Yeah, so I've noticed that I'm frozen, which apologies, everyone. That is frustrating, and I seem to have no easy way to fix that. So hopefully that will
It's not your best look, but we'll
yeah, stopping and starting the camera isn't doing the trick either. So oh well, we will just continue. So yeah, there's a lot of clauses that are the sort that create this confusion. So you might see less of this if you got a term like hosted software into your head, but even that isn't necessarily gonna solve the problem. So let's look at the overlap and the confusion between software as a service and on-premise software. So where do we go wrong? Really, the way to look at it is that people provide on-premise software. People provide software as a service under an on-premise software licensing model, so that they're doing deals that are based on on-premise software terms. So for instance, you might get terms that first and foremost grant an intellectual property license. I see this all the time. So instead of saying, as you really should, that a subscription is granted to access the software as a service during the term, you see lots of contracts that say a license is granted. You see contracts that says the vendor hereby grants a license to the software as a service, or the system, or however it's described. And it, sometimes it goes even further and gets specific that the license is a license to reproduce or something along those lines, which is utterly wrong. The reason that's a problem is the vendor really isn't granting intellectual property rights, certainly not copyrights to the software. It doesn't really work to say that the vendor is granting copyrights. What the vendor is granting is the right to remotely access and use the system. So if you're granting a right, if you use the word license, what you're doing is suggesting some kind of intellectual property license. At least that's a possible interpretation of the concept. Because license is so often used in intellectual property grants, you may run into the assumption that this is an intellectual property license. That can get the vendor into all sorts of trouble. On the vendor side of this, first of all, you could get into a dispute with the customer and find that there's an argument that you've actually granted a right to access to your software, which you certainly didn't mean to do. Or you could have all kinds of other problems. For instance, copyleft open source software obligations are often triggered by distribution of your software, by the granting of a license to a customer. For most of those obligations, most GPL obligations, other copyleft obligations, providing software as a service would not trigger copyleft. It would not trigger those obligations. But if you do grant a license, you create an argument that you've triggered those obligations. There are bankruptcy implications. There's all sorts of other implications. So for the vendor of software as a service, there's all kinds of problems you can create for yourself if you grant a license. All you need to say, and this is the language available at our site and in my book, the Tech Contracts Handbook, all you need to say is during the subscription period, customer may access and use the system. You're not granting an intellectual property license. So that's really on the top of the list. But you see other terms that are on-premise software based and are inappropriate. For instance, some people put in terms about whether and when the customer can modify the software, reverse engineering prohibitions, terms about derivative works. Those are all inapplicable. If the vendor isn't giving access to the software, you don't need terms, and they're just going to create rights and generate confusion. That's a problem. Sometimes you see people put in maintenance terms, a maintenance clause for software as a service. Maintenance is about the vendor coming onto your premises or remote accessing the software on your computers and fixing it when it's broken. Maintenance doesn't make sense. It doesn't apply to software as a service. Maintenance is a system for on-premise software. You want a service level agreement for software as a service. You see terms that fail to address the ongoing nature of the system. So on-premise software, you can have a one-time intellectual property grant. You grant the customer a license, and then in theory, the relationship is done. There might be maintenance. Software as a service involves an ongoing relationship. So the terms about interaction between the parties, about the renewal of the term, duration, et cetera, those are all different because this is an ongoing relationship. Finally, there's revenue recognition implications for those dealing with revenue recognitions. You need to recognize and understand that it's not like a sale of a product. Where in theory, the sale of software is a sort of one and done. It's not really a sale, but the grant of the license to reproduce the software can be granted during Q1 and then be done and paid for, and you can recognize the revenue for it. Whereas software as a service, it doesn't work that way. It's an ongoing obligation, and so under most systems, revenue recognition is going to be delayed. Those are some of the key types of mistakes you see related to the confusion between software as a service and on-premise software.
So how about the confusion between software as a service and professional services? Can you give us some examples of those kind of problems?
Yes, absolutely. So really the way I'd put it is that software as a service, I think while it's fair to say that it has features of both product and service, or you could say it's neither a product and service, where it really fits in between. It is at a fundamental level a lot more like a product than a service. At least I think it's fair to say, what are you really buying when you buy software as a service? You're getting use of this system. And so, what's the impact of that? It looks a lot like on-premise software in that you need the system to work and your focus is on the functionality of the system. And that's fundamentally different from a professional services deal. In a professional services deal, you're not buying a thing, you're buying assistance from people. So a professional services deal, you might have the professional services might be creation of information technology. It might be writing software, for instance, and those are deliverables. That's deliverables sort of, that's an on-premise software deal. You have what we'd call a mixed deal. You'd have some elements of both, but the fundamental thing you're buying is the assistance and services of those people. That's not really the fundamental thing that you're buying in software as a service. You're buying the technology. It does look like a service in that the vendor has to host it and run it and keep it going there. So, getting back to Kathy's question, where do you really run into trouble there? So first of all, you see people who put in all these sorts of requirements to their contracts for SaaS that relate really to professional services. They've seen the word service in software as a service, and they think that's what they're doing. So there'll be professional services warranties, like the warranty of professional and workmanlike services. Or warranties about training for the staff who's providing the services, or limits on the extent to which, this is a particularly common one, limits on the extent to which the vendor can subcontract the quote unquote services. None of that makes a lot of sense. The vendor is providing a technology. Of course they're subcontracting. There's always going to be some, data host, janitors cleaning up the data center. There's a million ways in which the vendor's subcontracting, which it wouldn't make sense to say no subcontracting allowed, as you might in a professional service, because there you're literally buying the assistance of humans. And it makes sense to say, we want your humans, vendor, not anyone else's. You also get, sort of on the flip side, the failure to include what I would call the non-human requirements of a software as a service agreement. So software as a service, you have terms like the uptime, 5 nines. You've heard that term probably. There's a service level agreement requirement that the technology function 99.999% of the time. So you get this uptime promise. That wouldn't make any sense in a professional services deal. Humans don't function that way. And if you're thinking in terms of professional services, you can very easily forget that you need those kinds of terms, that you need things like inhuman requirements. Another common mistake is people don't get an intellectual property warranty or an IP indemnity. The customer, in this case, again, is confused and treats the software like it's a professional service. You don't need an IP warranty for professional services. They're human beings. There's no IP that covers them. They might be using technology subject to intellectual property, but the customer isn't using it, and so doesn't need to worry much about intellectual property issues. Again, not the case with software as a service and other cloud services. You could be stopped from using the vendor's product as a result of an IP claim against the vendor, and you could be subject to a lawsuit for having used the vendor's product, because you are making use of it. You're not reproducing it under copyright, but you are subject to patent litigation and who knows what other kind of litigation. So again, treating this as a service could lead you to fail to get the IP warranty and indemnity protection you need. You might do things like failure to include things like technical specifications for the system. Fundamentally, what you're buying is functionality. So you want to have some kind of citation to specifications which say what the system is going to do, and most likely a warranty. Again, if you're looking at this really as a service, you're not going to do that. And actually, there's a lot of confusion between service level agreements and warranties. One of the typical customer mistakes is that they assume that because they have a service level agreement, they don't need a warranty. And that really isn't right. A warranty of functionality will generally cover everything that the system is supposed to do, whereas a service warranty, or rather a service level agreement, just covers a certain narrow set of things. So definitely you want, if you can get it as a customer, a broad warranty. So those are, again, all mistakes you'd make if you're looking at this as a source of confusion. If you're confused between software as a service, maybe better called hosted software, and professional services about IT.
That's great. Thank you. So we're out of time. Where can people go to learn more on this topic?
Yeah, let's do that, and then let's take some questions, and we can go a little over
Oh, sure.
time.
If you see any questions you want to grab, by all means.
I will. So first of all, in terms of learning more, I wrote an article that's called "Software as a Service is not," or maybe it's "Cloud Services are neither professional services, are neither products nor services." And actually, it's occurred to me since then. I could have said, software as a service is both professional services and on-premise software. That is both product and service. It really just depends how you slice it. But anyway, that article really lays out this concern that I'm talking about here. We will put a link to that article shortly after we're done here in the comments section. And then you can go there and read that at your leisure. So why don't we take some of the questions that came up. Let me look, hold on a second. So here's a question. Under a SaaS agreement, what is the best way to protect the data ownership, as it is a vital component of a cloud services agreement? So that's a good question. This is another of the types of clauses that we run into where there's often a mistake made. If you're thinking about your deal as an on-premise software agreement, you might not think to address data, because what would you need it for? In an on-premise software agreement, the customer's data is on the customer's computers, and the vendor has little or no access. But yeah, you need to certainly protect data in a software as a service agreement, because the customer's data is on the vendor's computers. Data ownership is not really the concept that I would be most concerned about in response to the question. You do want to say who owns the data. If you're the party, that is likely to be considered the owner, that's absolutely fine. But you've got to recognize that you can't have very strong or very meaningful intellectual property rights in data. You can't really own information, with some complex and weak exceptions. So yeah, say that the customer owns the customer data in a cloud services deal. But you don't want to just rely on that. You want to go from there and address clauses about control of the data. You want to recognize that the fact that you own the data doesn't mean the other party can't mine it or manipulate it or even reproduce it, because there aren't very significant IP rights in data. So you want a substantial clause which addresses all of the stuff that you need to do, that you want the other party to do and not do with the data. That's a data management and security clause. We've got a very detailed example at our website, techcontracts.com, and it's the clause from my book, the Tech Contracts Handbook. So that's the way to focus. Let me take another couple of questions. Again, everyone, I apologize that my screen is frozen. It is very irritating. But anyway, I assure you I'm still moving. So, okay, question. What about maintenance for a dedicated instance of platform as a service or SaaS solution, where the customer does not always need or want the most current version of the solution? So the answer to that question is yes. There's no absolute hard and fast rules. In a cloud services relationship, whether it's software as a service or platform as a service, you can have a dedicated instance. So what that means is, instead of the vendor hosting the same technology and lots of people accessing and using it, you have a single instance of the technology that's for you, the customer. And there we start to look a little bit more like on-premise software. It does make some sense, as the questioner pointed out, in that instance, to talk about maintenance. it does make some sense to talk about a vendor obligation to go beyond the service level agreement, which is the uptime and similar promises the vendor makes to all customers at once, to say, if your particular instance breaks down, this is what we're going to do to come and fix it. So the logic of maintenance makes sense there. You still often have it addressed in what's called a service level agreement, but it may start to look more like a maintenance clause. But even if you're in one of those dedicated instance type deals, do not forget that this still isn't really a product deal. At least it has differences with product type deals. You're not getting a copy. There's an ongoing obligation to keep the system running. In other words, there's still elements of service. You're still in that weird area between product and service, which, as I said, you could either say it's neither or it's both, however you like to put it. So yes, maintenance makes a little bit more sense there, but you're still talking about something very general. All right, let me take one more question and then we'll wrap up. Good question here. What are typical indemnification obligations that customers agree to? This raises a really interesting point. And again, it's unique to software as a service. When should the customer be providing an indemnity? You don't get a lot of indemnities from the customer in on-premise software deals. There's not a particular risk of a third-party lawsuit facing the vendor as a result of selling the customer. It's not unheard of, and there could be some particular concern. But you don't get a lot of indemnity terms. There are some other issues that arise in software as a service where an indemnity from the customer might start to make more sense. So for instance, unlike an on-premise deal, in a software as a service deal, the vendor, the customer is most likely dumping information, dumping data onto the vendor's computers. And anytime the vendor's holding data, it's got some concerns about third-party lawsuits. It could be, from the vendor's point of view, that data gets it into intellectual property or defamation issues. It could be that is information, that is rather content which is subject to somebody else's copyright or trade secret or trademark. Or it could be defamatory content and the vendor is effectively posting it online. And so, so spreading the defamation. And so in cases like that, you might want to have what I call a customer content indemnity, where unlike the usual IP indemnity from the vendor, the customer is indemnifying the vendor against lawsuits against the vendor, claiming misuse, that the vendor, by hosting that information, has violated third-party rights. And by the way, I've just talked about things like defamation and IP rights. Of course, it could be privacy rights. So the vendor could get swept into a data-related lawsuit, a very large lawsuit. One of the things that vendors should always consider is whether or not you're granting a data breach indemnity to the customer. Consider whether you need a data breach indemnity, whether you need to be indemnified against claims that result from the customer giving you private data that gets you sued that the customer didn't really have a right to. Or even if the customer did have a right to it, the issue lies with the customer's collection of data, and that's where the dispute is. And right or wrong, maybe you want to be protected from those sorts of lawsuits. So again, there's a series of other indemnities to think about where you have this hybrid relationship where it's a little bit like a product and a little bit like a service. All right, that brings us to the end. As I said, I will post the link to that article I mentioned. I want to mention too, of course, you see it running along the bottom of the screen. We provide classes on these issues, and first and foremost, our Tech Contracts Masterclass. That is a 4-part series, 2 hours each, where I teach the fundamental issues at stake in all IT contracts. And really, it's very comprehensive. We hit just about all of the clauses that are typical. Each of the sessions is 2 hours. You can either take, you can pick and choose the 2-hour sessions you want, or you can do the series of all 4. Either way, you get a certificate. We're doing a series starting this month, this coming month in September, and then another series starting in October. The series in September is a little unusual. You can only sign up for all 4, but in October you can sign up for all 4 or individuals. Anyway, all the information about the masterclass is at our website, techcontracts.com. So I hope some of you will join us there. And I hope also to see you again at our next LinkedIn Live session. Thank you very much for joining us. And thank you, Kathy.
Thank you. Bye, David.
If you found this video useful, please come check out Tech Contracts Academy. We provide training on drafting and negotiating contracts about artificial intelligence, cloud computing, and other forms of software. It's all for lawyers, contract managers, and any business people involved with contracts. So please come check out our programs live and on demand at techcontracts.com.